Hello, everyone, and thank you for joining another Outcomes for Me Ask the Expert webinar. Today, we're grateful to be able to answer your questions around estate planning. Estate planning is certainly not a topic that anyone truly looks forward to discussing, but we all know that it's incredibly important. It's a process that we all should be concerned about, regardless of our age or our current health status. But when you're navigating a cancer diagnosis or cancer survivorship, estate planning might take on a new meaning or be more nuanced than before. So we feel privileged to have today's expert with us to discuss the topic in depth. I'll introduce him in just a moment. But for those of you who may be joining for the first time, my name is Suzanne Garner. I am Director of Marketing and Community for Outcomes for Me. I am also a stage 2 breast cancer survivor. I actually came to work for Outcomes for Me after I found the tool incredibly helpful in educating myself and navigating my own cancer diagnosis. And one of the core missions of this company is to help empower patients to take control of their own care through educating them with evidence-based sources. So for today's webinar, I am honored to welcome Mitch Mitchell, Product Counsel at Trust and Will, which is an online estate planning service that was named both the Fast Company Most Innovative Company and most recently recognized as a CNBC Disruptor, an honor bestowed upon 50 private companies making a difference in the world. Mitch is product counsel at Trust and Will, as I said, where he acts as an integral part of company's internal legal team. He's board certified in estate planning and probate by the Texas Board of Legal Specialization. As an experienced estate planning and probate attorney, Mitch brings over a decade of knowledge and real life experience to Trust and Will's service offerings. Before joining Trust and Will, Mitch was a lawyer in private practice where he helped individuals prepare their estate plans and helped families navigate probate after the loss of a loved one. He earned his JD from Baylor University School of Law and lives in East Texas with his wife and 3 young children. So he's super busy outside of work and helping all of us with these sensitive topics too. So welcome, Mitch. Would you please start us off by just saying hello to our community and maybe sharing anything I may have missed about you?
Thanks, Suzanne. Appreciate the introduction. And I'll just start off by saying that I am always grateful to speak on this topic. Most of the questions that we're going to address are kind of what I view as foundational questions. Estate planning is a topic that most of us are not all that familiar with, but we're all super interested in it. And I think this is unique to me. I haven't addressed cancer survivors or cancer patients or their support network in a format like this. But I know that the topic's especially important to this group. And I'll just caveat, I'm a lawyer, so I'll give a disclaimer here. My answers are not legal advice. I'm trying to give you legal information here. If you have a specific situation that you need advice on, I encourage you to consult with the appropriate professional.
Thank you for that. Okay, we received a lot of questions, and we have quite a few people joining us today. So I'm just going to jump right in so that we can get through as many questions as possible. We've grouped our questions together into different topics, but I'm going to start out with just some table setting questions. So as you said, estate planning, that term, that whole process is something that not a lot of people are necessarily familiar with. So can you just start us off by giving a simple definition of what estate planning is?
Sure. Estate planning, I'll give a non-legal definition first and then give more of a lawyer definition. Estate planning really is just planning today for what might happen. Planning for illness or planning for what happens with our death. And then the more legal answer to that is estate planning is just the umbrella term for, a set of documents that we have an opportunity to outline what we want our medical decision making to look like when perhaps maybe we're no longer able to communicate those effectively. And then finally, to communicate our wishes when we're no longer here, who's in charge of administering our estate, who do we want our property to go to? And estate in this context, really, if you just substitute the word property, everybody has an estate, and that's really just a way of saying that they have property that they can, they have control over and can manage and decide what happens to it.
Okay, so it's relevant for everyone because my marketing brain says we should change that term because when I hear estate, I'm like, well, if I live in an apartment and my asset is my dog and my cooking equipment, I certainly don't have an estate because that sounds super fancy. But I like that, summing in the word property. Um, it is relevant and important for everybody to think about. So that leads to the next question that we got, which is why is estate planning something that is important to pursue?
So yeah, I say this often, estate planning is for everyone. Estate, I think, is a loaded word. It has connotations of wealth,
Yeah.
people who are wealthier than I am. And that's just not true. Every adult has something that they can plan for, that they can help their family members by laying out a plan in advance. So that's why it's important, is because we all have people who care about us and who need to know what our preferences and wishes are. If they don't, then they're entering what could be an uncomfortable situation. So having to decide what your end of life care is, maybe without having had that discussion with you in advance. Maybe having to guess about your wishes when you're no longer here as to like, did you want to be cremated? Did you want to be buried? Would you have left your property to these people that you didn't have a relationship with? So that's where we all have an opportunity here to kind of help our family members, help our loved ones by creating an estate plan. And again, you could swap out property, or you can really just take out the word estate, just make a plan, because that's what it is. It's both the healthcare aspect, which we'll talk about in detail in a moment, and the pure legal aspect of like making a will, making a trust. What are those documents and what do they do?
Okay, thank you. That's very helpful. Um, the next question I actually have wondered too. So is estate planning synonymous with will? Is that the same thing? Because that's just a more common term, or is estate planning like a supplement to your will or vice versa?
So I describe it this way. Estate planning is an umbrella term. It includes the category of documents that decide what's going to happen to my property when I die, and who's going to be in charge. So that's either a will or trust. And I think most people understand what a will is. That's a document that I write out, a formal legal document that I write out, and it's going to name an executor or personal representative. And the terminology kind of varies a little bit from state to state, but that's the person who's in charge of administering your estate. So they take possession of your assets, and what the will says about who gets your property, your beneficiaries named in there, they're going to ultimately, once expenses are paid, and the administration's over, they'll distribute what's left over to your beneficiaries named in your will. But estate planning as a concept is broader than that because it includes not just after death planning, what a will or trust does, getting property to people who survive you, but it also includes incapacity planning. So that is an advance directive or living will that says, if I am in a coma or I have a terminal condition and I'm not able to communicate my wishes, here's what I want you to do. And it includes a power of attorney for healthcare or a healthcare proxy where you're naming somebody specifically to be your agent to step in and make those decisions for you. And then it also includes a financial power of attorney, which is if I have accounts, I have bills that need to be paid, then I authorize somebody to step in again when I'm incapacitated and can't do it for myself. So it's really broader than that. It includes, sickness, and what happens whenever I'm no longer here.
Okay, thank you. That was really helpful. Okay, those were our table setting questions. We got a lot of questions about planning financially for both during and after a cancer diagnosis, and then what happens to our assets after we're gone. So I'm going to start to jump into those. And I don't know how young your three young children are, but I have a 10-year-old daughter at home who is very much a Swiftie. I don't know if you have any Swifties or are a Swiftie yourself, but this question made me think of the Taylor Swift song Anti-Hero, because in it, some of the lyrics, she talks about how she passes on and all of her kids gather for the reading of the will, and she didn't leave them anything. And they say she's laughing up at us from hell, right? So she had planned well with her will for where she wanted her assets to go. So this question is, my father was diagnosed with stage 4 cancer, and right now he's responding well to treatment, but we understand that his diagnosis is terminal. He is currently comfortable financially, but has several children, as well as a second wife who also has children. So that we can plan ahead, what are the steps you recommend we take to protect my dad financially now so that his wishes are carried out in terms of inheritance when he unfortunately does pass from his cancer?
Yeah. So this is, a specific question, and I'll try to answer it generally again because I'm not here to give legal advice, but it does help us jump off into good general rules, which I'll try to do in my answers today. So first thing is to have a written plan. This is something that is just foundational to us at Trust and Will. Mission of the company, very clear mission, is that 2/3 of American adults don't have an estate plan, so they don't have a will or trust. They don't have these important incapacity planning documents. And it's okay, like there are default rules that step in to help. But the importance of having a plan here, especially because in the example, there's a second wife who also has children. So that tells me, and this is not at all uncommon because, 50% of marriages end in divorce. So you have a lot of what we call blended families. And that's where the most common dynamic that I encountered when in private practice, when I was still helping folks make these plans, is, in the second marriage scenario, you probably, because you love that person, want them to have a certain level of comfort when you die. You probably, though, don't want them to get everything because maybe you have adult children who you think, I want to support them. I want them to have an inheritance. And so that's where having a plan helps avoid the default rules, because where I am in Texas, we're a community property state. And so anything that's community property is going to my spouse if I don't say otherwise. But I have, a half interest in my house that's community property that I can determine who I want to go to. And it doesn't have to go to my spouse. It will if I don't say anything, but it could go to my adult children. And so that's where having a written plan to say, here's what I want to do. Maybe I want to give her the house so that she can have a certain level of comfort, but maybe I have certain other assets that I brought into the marriage, substantial, savings that I say, I want my adult children to have it. So, just very clearly, it might be a will, could be a very simple document that says, I want my spouse to be executor or personal representative, so she's going to be in charge, but here are the assets she gets, and here are the assets that my kids get. So, you'll hear me say this often, but it's just so important to not just assume that it's going to work out, because odds are it won't. People, even the best intentioned families, there's a vacuum when this loved one's no longer here, and you don't know how people are going to respond to that. And you can help mitigate some of that, discomfort and hurt feelings by not only making the plan, but also communicating it. This is another important step, communicating in advance what you did and why. You don't owe anybody that explanation, but it's been my experience that it helps people plan for it, to say, listen, here's what I'm doing, here's why I did it, so that people, when they're grieving, don't have to focus on that. They already kind of had time to grapple with it, so they can spend time, however it is, grieving instead of fighting. So that, planning, communicating the plan, those are the two main takeaways in response to that question.
Okay. Okay. And I think I think that's a beautiful answer and would be ideal. But I'm curious, can it be more private? So can the individual work with somebody? Because what if they anticipate fighting while they're still alive and they don't want to deal with that because they're dealing with the overwhelm of their cancer diagnosis and planning for the end of their life, and they don't want to deal with the original kids and the new kids, everybody's opinion of the money should go. Can they work with a independent executor to have their wishes documented, and then everybody can just find out when it's
Yeah,
time?
so I think that that's a great follow-up question, and certainly you bring perspective of being a survivor here, and that's something that cannot be overlooked. Is we have a person that's struggling with an illness, very serious illness, advanced illness, and so maybe they don't have the energy to deal with the fallout of family dynamics. So yes, you can keep it private. So and you can name a third party to step in and manage this stuff for you. So like depending upon the level of wealth that you're dealing with here, some people may name a professional fiduciary, typically a bank, or some other financial institution that has professionals who do this all the time. And so you could just kind of keep that to yourself and say, I set up a trust. It's very clear. I don't have to tell anybody about it right now, but I've got a professional third-party fiduciary who's going to step in and manage this, and they have a clear mandate, and they don't have a dog in the fight about like what's going to happen here. They have, they're a professional, so they're going to do what's in the document instead of having to deal with, the family feud.
Okay, great. Thank you. That could be helpful to some. So you kind of went over this, but since this is so complicated, there was a specific question about, can you explain how a trust operates and why and how it's different from a will?
Sure. So they're both documents. A will and a trust are both documents that I set up now. That I draft or have an attorney draft for me that says, when I die, here's what I want to happen to my property. Where they contrast is a will is a document, a legal document that doesn't actually go into effect, doesn't have any legal effect until I die. And the process that gives it legal effect is called probate. So, and it's a court process where the first step of that is filing that original will with the probate court and, ensuring that document actually is that person's will, and then getting the executor or personal representative appointed. They don't have any authority until will's been filed. Court says, yep, that's Mitch's will. And yep, the person he named as executor now has authority, and they get letters testamentary, which is the evidence, the court document that says this person now has authority to act for Mitch's estate. So that's a will. All wills have to go through probate. Probate is a public court process. So when that will gets filed, like most court cases, it's public record. Anybody can go down to the courthouse and see, what did Mitch's will say? What property did passed under Mitch's will? Who's in charge and who are his beneficiaries? A trust, on the other hand, again, it's a document that I set up now, but the most common type of trust that is the one that we're talking about right now. It's called a revocable living trust. So the living part of it is it's something that I set up while I'm still alive. And the revocable part is like a will. Anytime while I'm still living, I can revoke it. I can change it. I can amend it. I can get rid of it. And it's a document though where I'm naming a trustee to step in and manage my assets right now. Now, most commonly when I set up a trust, I'm naming myself as trustee of my trust. But the important concept here is, a will has an executor, a trustee has a trust, And the trustee doesn't have to go to court. They have authority just because the trust says so. And, I can name successors, so I can name people to step in after me. But they don't have to go to court to get that authority. So anything that's in the trust, we just look at my trustee succession to see who's in charge. And also I can name beneficiaries and say, like, when I die, here's who I want it to go to. And none of that happens in a court process typically. So, the revocable living trust, again, most common type of trust that people use, its main feature, the reason people use it, is probate avoidance. It's also typically more private because, as I called out just a moment ago, probate is a public process, whereas the will, a will always gets filed with the probate court, which people can go and look at. A trust remains a private document, it doesn't get filed with the court. So, if you're looking for some semblance of privacy, the trust also helps with that.
Okay, thank you. We're getting a couple questions live. So it's sort of about location. So is this nuanced like state to state? If you do all of this documentation and then you move states, do you have to update any of these documents to reflect
So
that?
it's best practice to do so if you plan to live somewhere for a good while. I've lived in Texas for a long time, but I've also lived in New Mexico. I lived in New Mexico for 5 years. So I plan to stay there for a while. It was appropriate for me to have a New Mexico estate plan. There's a Each state is a little bit unique in how, like, what you can do in an estate plan, how their probate laws work. And so it's always a good idea if you plan to stick around in a particular state for a while to update your plan at the very least, or maybe go to an estate planning professional there and get just a new set of documents. Where that breaks a little bit is with the trust. Like, I could have a Texas trust set up and it can own property in any state. That's also one of the features is if I, say own a second home somewhere, then it's possible that I have to do probate in each state where I own property. Well, if I instead used a trust and funded my primary residence into the trust, well, anything that's funded into the trust will not go through the probate process. I can also transfer out of state property into my Texas trust and potentially avoid probate in that other state. So that's back to the original question of, like, should I change it? Best practice is to do so if you plan to be there for a while. At the very least, have it reviewed to see if it needs changes. Because one of the nuances is, like, if I had a New Mexico will and I moved to Texas and I never changed it, we have something called independent administration here in Texas, which is a big deal. It helps save a lot of time and money going through the probate process. And there's magic language that you're supposed to include in the will to invoke independent administration. So there are little quirks like that everywhere. And so my New Mexico will wouldn't call for independent administration with the magic language. And so potentially, the more expensive, more protracted process I have to go through. There are examples like that all over the U.S. where, again, if you plan to be there for a while, at least have it looked at by somebody who is locally familiar, if not having it fully changed.
Okay, thank you. Okay, this question, I have stage 4 cancer. Can you explain what an estate tax is and how my family needs to prepare financially for that cost? How do we mitigate the fallout from this?
So there are two aspects to this question. One is that there is a federal estate tax. And most people hearing me talk about this will never have to worry about that because there's an estate tax exemption where if your estate is valued less than that, your estate owes no estate tax.
Okay.
And so that's presently like $13 million.
Oh,
And for married couples, it's doubled. And it's scheduled though by 2026 to be cut in half. But
okay.
again, we're dealing with, $6, $7 million.
Right.
So most people, federal estate tax, not a concern at all. I think there are 12 or 13 thereabouts 12 or 13 states thereabouts that have a state estate tax or state inheritance tax. And those are typically lower. Washington's a great example. Washington State, I believe only have $1 million exemption. And so you think like if you own a house in Seattle, you think about property values there, is the way I think about them. I think it's probably much more common to have a taxable estate in Washington from a state standpoint. So that's where your estate has to pay tax on anything above the exemption amount. But hopefully my answer helps reassure a lot of people concerned about it because most states don't have an estate tax and most people have estates worth far less than 10 $12 million. And so I think with that information in mind, if you're in a state, Washington's one, Massachusetts is another one. There are a few, and you can just go online and do a Google search and find out if your state has an estate tax. If it does, and it's a lower threshold, which typically they are if they have one, then that's where, going back to my the previous question about what are the differences. If you are in a jurisdiction with the state estate tax, then you probably want to have documents that specifically address that. So it'd be a good idea if you're a Washington State resident now to have a Washington State plan that addresses, that works around, that deals with the state estate tax. Where, like, again, my example, if I'm a Texas resident, if I move to Washington State, I'd probably want to have a Washington plan instead of my old Texas will.
Yeah. Okay. Death and taxes, huh? Things we can't avoid. All right. Does joint property automatically go to my spouse when I pass? What happens to their share of our house, for example? How do I ensure my wife has full rights to the house outright? If we're both on the deed, are we all set?
So I like this question because it calls out, I think, a fairly common misconception. So in some states, yes, if you and your spouse acquire property together, you're all set. The trouble, though, is that's just some states. And so, again, just examples of what I know. In Texas, I own my house with my wife, and it says jointly, or it says husband and wife, something like that. That does not mean, though, that when I die, she gets the house 100%. I think a lot of people have assumptions about that. It doesn't work that way. So what would have to happen is my will would need to be probated to give her my share. Because my will says if I die and my wife survives me, then everything goes to her. So it's not automatic. There are deeds and there are ways that people typically take title. And this is all kind of decided by the title company that helps close your real estate transaction. So you probably didn't even think about it because in the giant stack of paperwork that you signed when you closed on your house, the actual deed itself that you might have signed or seen, I mean, you wouldn't have signed it, but the seller signed, you may not have noticed how it said you were taking title. So there are ways and there are deeds that people can use to have joint ownership, to have like an automatic transfer of title. That can be called a transfer on death deed, where I say when I die, and this avoids probate because it's just a deed, a new deed that I do. If I die, then my interest in the house goes to whomever. It could be my spouse or somebody else. So it's a transfer on death deed. There's another related beneficiary deed called a ladybird deed, which kind of does the same thing. And you know, to kind of circle back to the original question, it's not so simple. You kind of need to check how you have ownership. And depending upon your state, most likely the transfer to a spouse is not going to be automatic. So you either need to do a type of beneficiary deed, so maybe the ladybird deed or a transfer on death deed, or know that you're going to, that probate will have to happen for the interest in the house to transfer to your spouse.
Okay. Okay. I think that's a lot more complicated than a lot of people assume. This question's sort of related, and you might not know exactly how this mortgage part works, but this question was, I'd like to learn how to leave my house for my son, even though it's still not paid off. Can he just simply take over the mortgage payment?
So the general answer to this is that I can leave a house to anybody. So I can specify in my will or trust that I want it to go to a beneficiary, to a specific person. Generally, they take title for real property, which is our example here. They take it subject to any encumbrances. So anything that encumbers the property, like a mortgage or some other lien, they take the benefit and that burden. But not personally, it's just that it follows the property. So like if I take the house, somebody has to pay the mortgage. The mortgage doesn't just disappear. So simply, you can leave it to anybody. If you leave it to a family member, that especially like a spouse who's not already on the title, or a child of yours, then they may be able to assume the mortgage, or like they might be able to also refinance it. But of course, either one of those probably going to be dependent upon their credit, especially the refinance aspect. Or they can just continue to pay it as a practical matter. Because a lot of times, and this is more practical experience than legal advice, practically, as long as the bank is still getting their payments, as long as the property is being kept up and property taxes are being paid, so on, especially if it's a family member who's receiving the property, mortgage lenders don't, in my experience, don't care so much if the payments are continuing to be made. But sometimes, like your loved ones may encounter issues corresponding with the bank. Like they might say, well, who are you? You're
Right.
not our account holder. We don't know who you are. We don't have to give you any information. So you might not know the balance. You might not know the monthly payment amount. You might not know the escrow balance. And so that's where the process of probate might be helpful to that end, to have a court appointed representative who can get that information, who can find out what the payoff is, who can call up the call center and talk to somebody and say, I'm not only relative who's supposed to be getting the property, but I'm also legal representative of the estate. Give me a payoff. Help me understand what my options are here with assumption or refinance. And now it might be, assumptions might be more popular because rates are higher, at least right now. So continuing to keep that existing mortgage, but getting that property, the lien, the mortgage is going to follow it. And a family member may have an opportunity to assume it or refinance it.
Okay. Okay. That's so interesting what you said about the mortgage company just being happy to continue to be getting paid and not really paying attention to if the original mortgage holder is now dead.
Yeah.
So, because that could, if this particular person just communicated to the recipient of the home, in this case, the son, all the passwords and the way to access kind of the information regarding this. And maybe they were like me, no one get mad at me, but they bought their home in 2020 and have an interest rate of 2.8%. They want that to follow onto their child. So that's really interesting. And I didn't realize that could possibly be a
Yeah. It's one of those like practical things where yes, there's a little bit of the law being on your side there because there are some federal mortgage protections, and I guess it does kind of depend upon what mortgage you have. But most of your like traditional mortgages, they're going to be assumable. So the options are continue making the payments, assume it, which means I am becoming responsible for it. I am now legally responsible for existing mortgage, or refinance it, which means the old mortgage is getting paid off and now we have a new mortgage with a new interest rate.
Yeah. Okay. Um, thank you. Next question. If I set up a revocable trust, can my son, who is a beneficiary, still be named the executor?
Yes, and so this is makes me think of a conversation here about roles and responsibilities. So you can name, so the trust, as I discussed earlier, you'll have a trustee. So just to kind of build on this example here, I could name son as successor trustee, and he also be beneficiary of the trust. And then he can also be executor under a will. Now, for a revocable living trust plan, you have a special type of will called a pour-over will. And I probably should have described this earlier, but a revocable living trust, when it's set up and fully funded, and what I mean by that is any property that would have been in my name when I die, that goes through probate. If, however, I fund it into my trust, it avoids probate, or if like a 401k, I have a beneficiary designated on it, it goes directly to the beneficiary. The pour over will exists for any property that I might have forgotten to put into my trust, or just didn't know about. It pours over those assets into my trust, and my trust is still the central clearinghouse for my plan to say, here's who my beneficiaries are, here's who gets my property. So in this example, son could be successor trustee of the trust, he could be executor in my pour over will, and he could also be beneficiary. And then the last part of the question is, does it matter if he lives out of state? Practically, sometimes it does. And then even some states will have requirements about who can be executor. Like they want to have residents of that state be executor. And kind of the rationale behind that is they're fiduciaries. So they owe a duty to third parties, to beneficiaries, basically not to rip them off, to act in their interests. And courts generally want people inside their jurisdiction, inside their borders, so they can more readily hold them accountable if they violate their fiduciary duties. So I'm not sure about Georgia. I think Florida is one state that does have kind of a residency requirement, but if you're a surviving spouse, you don't have to be a resident to be executor. But I think maybe child you might have to be. Otherwise, you'll have to get somebody else to serve. But that kind of varies state to state. In Texas, we don't have a residency requirement for the executor. You do have to have a resident agent. And that's just somebody who can receive mail or legal notices that is inside the state. And so usually that's your attorney who's helping you through the probate process. They'll file a piece of paper with the court that says, here's where those notices need to go.
Okay. What exactly would you recommend this person Google to find out if applies to Georgia, so they know. If they can-
So the Google search would be Georgia executor resident, and see what you find.
Yeah,
And
okay, but you
like
guys
it
can
could be
help with
for
that.
could be for your state. And generally, with a search like that, you'll find law firm blogs, because they're looking for search hits for people looking for legal representation. You'll find a law firm blog that might explain the law, or you might look out and find the statute, the piece of law that requires or doesn't require somebody to be a resident to be an executor.
Okay, thank you. Um, all right, I am not legally married, but I have a common law partner. What are the extra steps we need to take to ensure our joint assets go to one of us and not a legal next of kin?
Um, so common law partner, um, this one's tough because I think most states recognize some concept of common law marriage. Um, and again, Texas does, or informal marriage. It kind of depends upon your state as to what they call it. But that's where your relationship, even though not like you don't have the marriage certificate, you've met certain other elements that the law says will give that relationship the same kind of sanction as marriage. That's tough though, because if there's no formal evidence of it, then uh, it can become an issue, especially if there are other family members who, if there was no marital relationship, even an informal marriage, they would get it. And so it's just an opportunity for people to fight over, are you married or are you not? And if you didn't take the formal steps to do it, then you are on shakier footing. And so uh, the best step for somebody to take here, aside from formalizing their marriage, because maybe that's not an option for whatever reason, is to have the written plan that says, I want it to go to this person, and vice versa. Like when I die, I have a will that specifies this person, whatever their relationship to me, whatever the law recognizes or doesn't recognize, I want my property to go to this person. And that also is a factor for other important relationships. Like maybe they're not even a common law spouse. Maybe they're just a long-term partner, or girlfriend or boyfriend, what have you. It's important, if you want something to go to them, to make a written plan that says that, because otherwise the default rules do not help you, and there's potential uncertainty there.
Okay, thank you. All right, I'm going to move on from our section on financial questions. And we have a couple that are specific to healthcare. So this member of our community asked, I know about a healthcare proxy form, but I keep hearing from the social workers at the clinic about advanced care planning. Can you explain what that means? What are other considerations I need to think about when it comes to my health and estate planning?
Yeah, so I'm glad we moved into this topic, because it's actually, I think, the underestimated important part of estate planning. Under the umbrella of estate planning, I talked about incapacity planning. And so we have healthcare decision making in that umbrella. And the healthcare proxy form, and the terminology differs from state to state. So there's healthcare proxy, healthcare agent. You can name an agent under a healthcare power of attorney. Those are all similar concepts where I'm naming a person, a representative or proxy, to make decisions for me. Now, that may or may not be coupled with, here are the types of decisions I want you to make. Here are my wishes. The advanced directive aspect typically is like, I want artificial nutrition or hydration, or no, I don't. Those are advanced directive type wishes. And they're all related. So my agent should honor my wishes and should know my wishes too. Um, but the agent is, I'm giving them authority to make decisions. That directive part is, here are the types of decisions I want you to make for me. If I'm not able to communicate them otherwise.
Okay, thank you. Um, how is end of life planning different from advanced care planning? I don't have a terminal diagnosis, so do I need to worry about anything other than my healthcare proxy?
So this is a good question because it touches on one of the nuances, and uh, the forms are kind of similar from state to state on this. I mentioned artificial nutrition, artificial hydration. There's, life-sustaining treatment decisions. And the form I'm thinking of, the form of advanced directive, has like, it defines a terminal condition, so that would be cancer, or an irreversible condition, that might be a coma. And of course, you can have both at the same time potentially. But that's where like end of life planning and advanced care planning kind of dovetail together. And I think even if you don't have a terminal diagnosis, there's an opportunity there for you to consider end of life planning because we all during our lifetime, odds are, will experience a serious illness of some kind. It might not be terminal, but it could be something where maybe we're just in an accident. And so we are under at that time and can't communicate. So you have an opportunity to make advanced decisions about what that looks like. And like, if you code it, do you want them to resuscitate you? Do you want them to leave you alone? Um, you have an opportunity to make those decisions whether you have a terminal condition or not. But you can also, again, in the form I'm thinking of, the Texas Advanced Directive, you can split what your decision is. If it's a terminal condition, here's why I want it to be treated. If it's an irreversible condition, here's how I want it to be treated.
Okay, thank you. Um, so that I think is most of our questions here. Um, there is one, just the practical matter. I can't afford an estate planning attorney. Are you aware of any resources that can help me with all the paperwork that aren't cost prohibitive?
Um, yes. So there are resources, and several states will have forms. So I've been talking, or at least I should make it more plain that like the forms that I've been talking about for incapacity planning, usually those are forms provided by a state. So there's a statutory form, which just means that um, your legislature has passed a law that says either use this form or here's an optional form for you to use for making these types of decisions. That just helps with uniformity so that like healthcare providers are familiar with the form. They're not looking at it and having to interpret it necessarily. So it helps with adoption. And so those are generally widely available. And I just encourage you to run a Google search for your state advanced directive form, healthcare proxy, and you'll probably find something. And usually like there are legal aid resources too, or yeah, care organizations, elder care organizations, other healthcare organizations that provide PDFs of these forms for people to fill out, and maybe even some instructions. So those are available, and that's incapacity planning. It's a little more difficult to find wills or trusts, but there are also some legal aid organizations who have fill in the blanks. So that covers free, and free might not be available for all of those, but it might cover some of those. Um, the there's also just more affordable than going to an attorney, and that's where services like Trust and Will, help fill a gap for that need, which is $199 for an individual will package, which includes will and all of those incapacity planning documents I've been discussing. And then there there are attorneys as an option at the other end of the spectrum. Typically attorneys in this space, especially if you say, I just want a simple package, a lot of them will, instead of billing by the hour, which attorneys are universally reviled for, will provide flat fee planning, so you at least are not surprised about what it costs. It might still be expensive, but you know what it's going to cost, which is one of the main gripes about using attorneys. I don't know how much it's going to cost. It costs me every time I talk to them. So that, you know, there's free, there's lower cost, where Trust and Will comes in, and that's because we're able to offer those documents separate from attorney advice. And then there's the relatively bespoke option of paying an attorney for their time so that you can get personalized advice and personalized forms.
I see. Okay. Yeah. So a lot of different options, just depending on your own personal financial situation and really the complexity of the plan that you need to put in place. That's awesome. That's helpful. Um, okay. Does anybody on the call have any last minute questions? You can just put them into the chat box and we can ask Mitch now. Um, no? Okay. I think this was a really good overview. Mitch, thank you so much for your guidance. This was really helpful. We got through a ton today. If you, for those on the call, if you have any questions that you think of after we wrap right now, email us at questions@outcomesforme.com, or if you have the app, just from the home screen of the app, there is an Ask Now box in the app, and you can just type your question in there, and we will get it, and then we can get in touch with Mitch, and then get answers back to you from Trust and Will. So Trust and Will, for our members, they're offering right now a 20% discount on all of their services. So if this is something that you've been considering doing and you want to take the next step, please visit them. They are able to offer 20% right now. We will, after this webinar, follow up and reshare a link to the special Outcomes for Me link that will allow you to sign up with the 20% off and take advantage of that benefit. If there are topics that, because this is really complex, that you want to revisit from our chat today, we're also going to make a recording of this webinar available. So either to watch yourself, or if you want loved ones to listen and benefit from the education, we will make that available to you as well. To make sure you don't miss any future updates, please, if you haven't already, download the Outcomes for Me app and enable your push notifications. Mitch, thank you one more time for being with us today. This was super valuable. Thank you for everyone who joined, and have a great rest of your day.